So let's make sure we got these glasses together, because we're going to get into this. Now let's start again. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, lead prosecutors proposed that the parties try the case clean, based on only what happened under the tent, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. So they were not supposed to go into any type of character or reputation or extraneous conduct evidence. They weren't supposed to get into that. So all of that with the damn prosecution talking about who was the agitator, who initiated all of this. They wasn't supposed to be doing none of that based off of the agreement to try the case clean. Y'all picking up what's being put down? Let me know. The terms were negotiated in a meeting and calls on May 5th, May 8th, and May 11th, and on the 21st. The parties presented understanding to the court itself in chambers off the record. I'm going to say that again, in chambers off the record, to avoid media reporting on bad act evidence. The understanding was memorialized only as a deliberately generic motion, hand delivered to the court on the first day of trial. It does not appear in the public docket. Did y'all hear what I said? Did y'all catch that? They made this try the case clean agreement off the record. And the only way that it exists is through a hand-delivered generic motion. Oh, baby. Oh, we go into it. What they said, Exhibit 10. Is that Exhibit 10 and 2? Hold on. Oh, we got to see this. Oh, I don't know if we're going to read all of that. Oh. Mike Howard. I don't even need my glasses for this shit. Mike Howard, was the trial counselor. I just skipped over that whole first sentence, okay? Supported by the second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupita, and briefing appellate counsel Michael Mauler, who represented Karmelo Anthony in cause number blah, 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 leading up to June 1st, 2026, trial of this case. So, the lead prosecutor in the case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent. okay, at the stadium on April 2nd, 2025, and not go into character, reputation, or extenuous offense and or bad act evidence applicable to either Austin, Hunter, or Karmelo. So they were entering into an agreement where they could not mention any of this is what, hold up. Get this back for a second. Hold up. Wait a minute. Wait a goddamn minute. Hold on. Do y'all realize what we just read? They didn't want any character, reputation, extenuous offense, or bad act evidence against either Austin and Hunter Metcalf or Karmelo. Since the trial, that cheerleader email was very detrimental to this case. Y'all do understand that, right? Because it spoke to their character, their reputation, extraneous offenses, and bad act evidence. This agreement had absolutely nothing to do with Karmelo and everything to do with protecting the Metcalf twins' reputation. You said, where was Karmelo's so-called lawyer to object to this? They agreed to this, King CJ. His lawyers agreed to not allow any of this to come into trial. They wanted to run the case, quote unquote, clean and keep it to what happened underneath the tent. And because they kept it to what happened underneath the tent, they were able to demonize Karmelo Anthony. Those lawyers agreed to protect those twins, even with Karmelo Anthony's life on the line. Give this boy a new trial and have the truth come out. Because I'm telling you right now, I don't believe that Austin Metcalf was the aggressor that day. I believe Hunter started that shit and Austin went to go finish it. Just like his brother said in that interview. And I know a lot of people are talking about that video and it was altered and it was fake. I pretty much stand on what I saw in that video. I believe the Metcalf twins tried to jump Karmelo. There it is. There it is. I'm going to read it one more time. When mentioning the proposed agreement, Mr. Worski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, and not go into character, reputation, extenuous offense, and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. So they protected these boys all the way. On May 5th, Mr. Shook and Mr. Worski discussed the proposed agreement by phone. During the call, Mr. Shook and Worski discussed the evidence of character, reputation, and extenuous offense bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Worski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. This is some motherfucking bullshit. If y'all don't get this boy a new trial and y'all don't tear motherfucking Collin County up, I don't know what to say. On May 8th, the defense and the prosecution teams met in Collin County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extenuous Offense, hereinafter state notice. And we gave to them a document entitled Anthony's Motion to limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor role, the evidence under text code criminal. We're not getting into any of that. Okay, defense notice. After tendering to each of the other respective extraneous filing briefings, we then discussed the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Mr. Worski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extenuous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent. And during another description during that meeting, what happened on the day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extenuous offenses, act or acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this time frame. As well as racism. Let me read this again. And I'm going to read it without raising my voice. Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses, acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this time frame, as well as racism. In exchange, the prosecution would not go into character, reputation, and extenuous offenses, act or acts, evidence relating to Karmelo Anthony, inclusive of contents of Karmelo's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, how to handle the possibility of repeatedly express, wait a minute. My mind just went kaboom. Give me a second. Let me sip some water for a second. My blood boiling right now. You want to tell me that this ain't no good old boy shit that we reading? You want to tell me that this was a fair and just motherfucking trial? Where all them people at that was coming in these comments with all that hateful racist shit that they were saying? Where they at? Where they at? Where they at? Because what I want y'all to pay attention to and what we just read and what's like boggling in my mind right now, like really like going, is when they start talking about the things that they're not going to mention, right? When they talk about the things they're not going to mention, they talk about the character, the reputation, extraneous acts or actor, et cetera, et cetera. But when they talk about the Metcalf school records, they say the school records within this framework. as well as racism. When they get to Karmelo Anthony, the additions to Karmelo is his cell phone and school disciplinary records. Well, we already had the girl that was interviewed that said that she was surprised that Karmelo, she only knew him for fighting. So obviously he had some school fights and scuffles. But there's no mention of racism on what they couldn't mention when it came down to Karmelo. So why are we mentioning racism with the Metcalf twins, huh? Huh? Yeah. Yeah. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During the meeting, Mr. Swirsky repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses, by witness interviews by police and captured by video on the day of the incident. So they have witness statements that were captured on video from the day of the incident. Were those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Isn't that what their mother said? They were told to change their testimony. They were coached on it. There's no getting around it. I'm getting heated. I'm getting heated. I'm getting heated. I'm getting heated. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements the witness made to police about the incident under the tent on April 2nd, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open the door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of agreement, being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt/innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt/innocent phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extenuous offense/act evidence. So the reason they never got anybody to come up there and testify to the fact that Karmelo had epilepsy is because of this agreement. The answers are here, and the chickens are coming home to roost. Y'all are hearing it for yourselves. So the witnesses could get on the stand and they could testify. And that wouldn't kick open the door. But if you bring a witness on the stand to testify to his epilepsy and how it put him into fight or flight mode, that it would violate the agreement and open the door to character, reputation, and extenuous offense acts evidence. That's why Karmelo ain't want to get on the stand. Let's continue. Lifeboy TV, you ain't never lied. He said, you get hit in your head, have a seizure, game over. They wrong. Yes, passionate meaning aggressive. That's not a character trait, though. They did him dirty. Big time, big time, big time, big time. On May 11, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During the phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if a thing occurred, he will respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard. I love my son. Please show mercy type testimony, but no further. This is why she gave a basic testimony. And let me explain something to you and how this makes Jeff Metcalf such a despicable, vile human being. He knew about this agreement. He knew about this agreement. And then he got his ass on that camera with Sarah Fields and painted such a dirty narrative about Karmelo's mother. They trusted their lawyer too much. I want to cry for this boy. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreed not to get into character, reputation, etc., etc. We know already. As it applies to both sides during both guilt, innocence, and sentencing phase, as long as no doors are open or false impressions given. We agreed that the best way to document such agreement would be for the defense to draft a file motion. I don't know how to say this word. Lemine? Is that how you say it? Come on, let's find out together. Let's find out together. I cannot believe this. I have such an attitude right now. I have an attitude. I can't believe
in limine.
Limine? No, it's not in limine. In limine. Okay. In limine, applying to character, reputation, and extenuous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad acts, evidence specific to certain witnesses, thus endangering a fair trial. This is why the judge needs to be recused. As a judge, you sat there and you listened to this agreement. And you allowed this backdoor, good old boy shit to happen in your courtroom. He needs to step down immediately. And they need to do a full investigation into every case that this judge has sat on and presided over in Collin County that includes any person of color. I don't give a damn if it was a parking ticket. Do you hear me? And they made the defense file it. And they went for it. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on opening day of trial. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any other eyewitness to the incident under the tent in April 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses such as memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. I'm getting upset because I already see where this is going. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution. On May 29, 2026, after a meeting with Judge Roach, the prosecution and the defense to discuss how trial security would be handled, the parties discussed the timing of the state's case in chief and when the defense's case in chief would start. Mr. Worski informed the courts and defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended on Saturday, June 6th. In response, I voiced concerns to the judge in front of the prosecution team that some of the witnesses and defense anticipated calling to testify were unavailable on Saturday, June 6th. I explained that, like in any case, I would not know until the final moment whether we could call our client for sure. but that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. On Friday, June 5th, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether we would end up taking more or less time to present his case in chief than he likely had estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated, so the prosecution was on track to rest its case in chief midday Saturday. In this conversation, Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday. And if the judge proceeded with this plan to force the defense to call witnesses immediately upon prosecution resting in order to have a full day of testimony on Saturday, he might be forced to call our client out of order. This time I did not preface the statement and was perfunctory. I don't know. I don't even care what he said at this time. Like in any case, I would not know if I'm going to call my client at the last minute because I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense's intentions to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mauler describing the problem we were facing and asking Mr. Mauler to draft a brief for us to argue to the judge that he could not force us to call our client out of order. Throughout the morning and early afternoon of Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notice and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to other sides' witnesses, Mr. Worski made references to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated and unknown to Mr. Anthony via the ambiguous aggressor rule. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the descendant in the murder case are all part of self-defense argument. Tories discussed in depth how ambiguous aggressor rules allow the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres and discusses with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated a discussion of Torres and how it may apply to the trial, showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Hunter and Austin and Hunter Metcalf, and the defense from the defense's perspective The entire agreement centered around the defendant testifying without impeachment by character, reputation, or extenuous evidence in exchange for the defense not seeking to introduce character, reputation, extenuous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony, free of impeachment. Just like every other witness, either side could have testified about what happened under the tent that day. I think we all know. I think we all know where this is going. Throughout the trial, the defense revised its trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness. The prosecution called about Austin and Hunter Metcalf's character, reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd, 2025, regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, and being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid, something or whatever. And then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told police that Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you could tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. They are exactly what we said they were. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having loud mouths, being passionate, etc. That had been deemed to be allowed under the agreement in the abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology-related expert would open the door to character, reputation, and extenuous evidence pertaining to Karmelo, the defense chose not designate any expert and ultimately chose not to call as a witness a neuropsychologist to discuss how Anthony's epilepsy impacted his perception of threat and response, as that is relative to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applies to Anthony's actions. As a result of this revision, the defense strategically, in the defense strategy, the defense did not go into the subjects during voir dire or opening statements. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire, would have introduced these topics during its opening statement. In sentencing, in reliance upon agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been victim of in his home. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witness Adam Lynn Wood, Jeremiah Smith, Jose Andre Ramirez Mora, before ending the day in the late afternoon, early evening. On Monday, June 8th, the defense resumed its case in chief, calling Brandon Steffens and Brennan Lancey. The defense's next planned witness, Blank, had been avoiding the defense subpoena and kept changing the time. He told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if Blank had arrived. During the 10:50 a.m. break, in the back hallway outside the judge's chamber, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that the testimony about epilepsy was irrelevant at guilt and innocence, and to the extent it was relevant, would open the door to character, reputation, and extenuous evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extenuous evidence in any way. But Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt innocence and would open the door to character, reputation, and extenuous evidence. Based on this, I informed the court that I would not call the coach and that I anticipated having 1 to 2 more witnesses before I called Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decisions regarding testimony. But I was 99% sure he would in fact testify. So they were talking to him about Fifth Amendment rights. You were going to have that boy plead the Fifth? After a break, back in court before the jury, to give Blank more time to arrive at the courthouse, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, I then decided to call Blank as a witness, and we broke for lunch around 11:17. And the prosecution and defense team stayed behind to talk to the judge outside the jury's presence. On the way back to chambers, Mr. Worski mentioned to Mr. Shook that, from his perspective, I had already opened the door to character, reputation, and extenuous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. Jesus Christ. Jesus Christ. And because the prosecution had already stopped their case, there was nothing that they could do at this point in time. And I seen this coming. They set this boy up for failure. I did not say anything about a chess club at any time during my opening statement. I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski and Mr. Mitchell, Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and defense never contemplated a testifying defendant. He elaborated, stating that he had never thought we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying Mr. Anthony was a member of the chess club. It is important to note that this was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense team had conferred many times throughout the prosecution's case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Judge Roach told both the prosecution and defense teams that my mention of chess during the opening statement definitely did not open the door to character, reputation, and extenuous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and if we called Mr. Anthony to testify, character, reputation, and extenuous evidence pertaining to Mr. Anthony were in fair play. Furthermore, Mr. Worski stated at that time that the prosecution already having rested character, reputation, and extenuous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion developed into a shouting match. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony, should the defense now choose to call him. After about 10 minutes cooling off period, Mr. Worski and I met in open court outside of the presence of the jury and without the public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to the agreement being breached. That's all. I'm tired of saying this shit over and over again, okay? To the evidence being breached pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that my mention of playing chess opened the door to character, I resolved that my only choice was to go over my plan outline of Mr. Anthony's direct examination line by line with Mr. Worski to determine what would and would not, in Mr. Worski's view, open the door. Now stop. Why do you have to give him a play-by-play so that he can counteract? I've never heard of no shit like this before in my life. What kind of lawyers are these? This did not help him in any way. You backed him into a corner and jammed him up. You put him out there on the blade. I have never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. Exactly. So he knew what you were going to do. That's what that was about. And he could counter. But as a defense team, we agreed that we had no other option if we wanted to try to reach an agreed understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline, Mr. Worski standing, reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to violating the agreement pertaining to Mr. Anthony. During this discussion, Worski repeated his claim that my earlier mention of chest opened the door. While I disagreed with all of Mr. Worski's assertions of subject that would open the door, I agreed to cut them from my questioning in hope of salvaging the agreement to keep Mr. Anthony's extenuous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of testimony in the abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process we had just gone through and our renegotiated agreement on record. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being opened. For example, if he said that he bought the knife by accident or said that he was scared, etc., that would almost certainly open the door to character, reputation, and extenuous evidence of some sort. I can't read. I need a break. I need a break. I don't want to read the rest because I'm getting heated. We all said they railroaded this boy. People have said that he was systematically lynched. We're reading it. We're reading it right now. They took him out to the slaughter. How could y'all do this? How could y'all do this to a young man? I hate to be right. This boy didn't stand a chance. They set him up to take the fall. I would not be. You said who gave this information to the new team? It's in the case file. It's in the case file. This is a statement that the previous attorney wrote. This ain't the new attorneys talking. This is one of the previous attorneys talking right now. You must have been late, Miss Black. They definitely need to be disbarred. They need to be sued for malpractice. But they didn't just set him up. They set the family up too. To preserve the Metcalf twins. And Jeff Metcalf, he runs his mouth so much Because remember when he talked about how they allowed the video to be shown, how they messed up when they allowed the video to be shown? I don't know who you are, Bluey Cluey, and I don't even know if you're being funny. My heart aches for this boy. He knew. He just was so smug, and he just knew this will never come out. To clarify the issue, I proposed a hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement. So, here's the thing. The judge couldn't enforce the agreement. And that's what I just explained to you. This is coming from the old attorney. The previous attorney typed this up. This is evidence in the appeal case. That's how they got this. Because the previous attorney, one of the previous attorneys, sat down and typed all of this out for them. It's in the file. So this is not the new attorneys reiterating something or regurgitating something that was given to them. This is the previous attorney. Ooh, baby, this case has got me like... If I and even the judge felt that So the judge is already letting it be known that no matter what Mr. Worski does, the judge cannot enforce anything. So there's nobody to back up the defense at all. They're all on the same team. Judge Roach and the prosecution on the same team. Why would they enter into this agreement? Anyway, the judge would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood, the door would have been opened. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. You got 10 minutes to tell your client You got 10 minutes to tell your client that they're not going to be able to testify on their own behalf because of the agreement. Y'all hands are tied. During the initial meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened with the help of Mr. Shook and Miss Gupta. I don't know. The female bad attorney. We then returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and to also explain that if he testifies, Judge Roach believes that he has no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach gave us 10 minutes to discuss the Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. So you put this young man's life, you estimated making a life-altering decision. You broke that down into 20 minutes. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined. He declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we would get instructions in the jury charges on the lesser included charge of manslaughter and criminally negligent homicide if he did or did not testify, and the likelihood of whether he could get instructions in the sentencing jury charge. If we got there on sudden passion, if he did and if he did not testify. During the discussion beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Mr. Anthony's extenuous offenses, bad acts, character, and reputation. Based on his actions and claims, specifically, he repeated assertions even after the judge had firmly disagreed that I had opened the door by even mentioning Chess, as well as his general claim that the agreement had never contemplated Mr. Anthony testifying, despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of agreement, he felt he was able to enforce it, and that in all likelihood, the door would have been opened. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision to proceed with trial. Ultimately, Mr. Anthony did not testify. This 180-degree change in the defense strategy was the direct subsequence of the breach of agreement. The breach of the agreement affected all aspects of the defense case. By the time that agreement was breached, it was too late to change our position in voir dire and opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions asked of the one witness we did, in fact, call. The prosecution's breach of agreement directly and significantly undermined the defense's ability to present a complete defense.